This is Michael Popok, Legal AF. What do Donald Trump and crypto genius, now convicted felon Sam Bankman-Fried have in common? Both are trying or tried to use the reliance on advice of counsel to avoid their criminal conviction. And just as it didn't work for Sam Bankman-Fried, it's not going to work for Donald Trump. And Judge Chutkan, who's overseeing the D.C. election interference case, has called Donald Trump's bluff, told him to put up or shut up by the January the 15th and tell her exactly which lawyers, or should I say, which convicted criminals that he relied on, and what exactly is evidence that supports his good faith reliance on advice of counsel. In other words, what documents do you have, Trump? What communications, what emails, what memos? And in order for that to work, and I'm going to tie it back to the Sam Bankman-Fried trial in a minute, because there's a procedure that goes on here with the court as the gatekeeper, because we have to always, and the judge is always concerned with protecting the jury in this criminal justice process. The jury in the criminal justice process is just, if not more important than the judge, and is the trier of fact. This is the reason in our American system of jurisprudence and justice, we rise for the jury. We don't just rise for the judge when we're in the courtroom. When I'm in a courtroom and I'm trying a case, even if I'm not trying a case, if I'm in the back watching a case and the jury enters the room and the marshal announces, the deputy announces, all rise for the jury, there's a reason, because they are the most important thing in that courtroom and to our public right of fair trial under the Constitution. So as the gatekeeper, the judge plays an important function to not allow experts who aren't really experts to testify in front of a jury, to not allow irrelevant evidence to go to the jury, to not allow evidence that maybe is relevant but is so prejudicial that it can't go to the jury. It would blow their mind and have them make a decision not based on the evidence, and therefore bar that evidence. Or in this case, to decide whether a defense that the defendant wants to use has any merit or basis whatsoever, because you don't just get to throw anything up against the wall in a criminal federal trial and hope it sticks. Yes, the government, the prosecutor, has the duty beyond a reasonable doubt to prove somebody's guilt, but the defendant can't just use any old defense in order to blow the mind of the jury and create reasonable doubt. And that's why the law, for instance, in the area of reasonable reliance on advice of counsel, has steps that have to be followed and hoops that have to be jumped through before a defendant is allowed to do this. We're seeing step one right now, and then I'm going to tell you what happened just recently, just 2 weeks ago, in the Sam Bankman-Fried crypto FTX collapse trial that led to his conviction, where the judge in that case, ironically, Judge Kaplan, who presided over Donald Trump and his E. Jean Carroll rape and defamation case, had to determine on the fly in a breakout evidentiary hearing with the jury excused whether that particular defense would be allowed or not. Here first are the elements. In order for the advice of counsel to be used as a common law defense, a defendant is determined not to be held liable for his actions if it's based on reasonable, and that's an objective standard, reliance on the advice of counsel. But there have to be 4 elements established, and we're starting to see the judge put Donald Trump's feet to the fire on each of these elements. 1, the defendant, in this case Trump, made a complete disclosure to counsel concerning the matter at issue. Complete. Not hold back any facts. Not play one idiot lawyer against the other. And we're talking about Jenna Ellis, Jim Trupis, Rudy Giuliani, Sidney Powell, sorry, had a momentary lapse there, Sidney Powell, and the rest, right? Those are the lawyers we're talking about that he allegedly relied on. So then you have, there has to be complete disclosure to those lawyers. 2, the defendant sought advice as to the legality of his conduct. He actually asked them, can I do this? Is this allowed? Giving them a complete and full picture of the facts. 3, the defendant received advice from one of these lawyers that I've just identified, including Ken Chesbro, add him to the list. Boris Epstein, add him to the list. that he got advice concerning his conduct. And 4, the defendant relied on that advice in good faith. And things that can destroy good faith is when you know or should know that you lost the election. So in order to get there, you waive your attorney-client privilege. All the documents that normally would be privileged now come in. You can't both assert the attorney-client privilege to shield the documents and claim the privilege and try to put a defense in front of the jury. That's called using it as a shield and a sword. You can't put up the defense as a shield and then claim you relied on lawyers' documents and information and communication, but I can't share it with you because it's attorney-client privilege, and use it as a sword. That you can't do. So that's the first thing that you have to do. Now, in the Sam Bankman-Fried, which is the most recent example of how a person like Donald Trump could use it, the judge stopped the trial before he took the stand. Once he decided to take the stand in his own defense, because that's really where this comes up. You have to take the stand. So that's the other thing that the Judge Chutkan is smoking out with Donald Trump. Are you going to take the stand? Now, he doesn't have to actually take the stand and make the decision today. He can make it at any time before the jury is given the case for deliberation, whether he's going to defend him, take the stand. But in advance, the judge wants to know, who are your lawyers? What'd you tell them? And what's the information that you claim supports the reasonable reliance? And give me all your communications between the lawyers. If you're not going to do that, you're not going to be able to ever mention the words reasonable reliance on counsel ever again. If the only way you can continue to maintain that position is if you give me all of these things, this is Judge Chutkan, by January the 15th. So she's going to smoke him out right now. If he misses that deadline, he is not later going to be able to argue, I want to go on the stand and raise reasonable reliance. No, I'm sorry, that time has passed. Let's say he tries to do that in March or April. January, I told you that was the deadline for it. And that's a reasonable deadline that comports with due process, and he won't have an appellate argument that she made him decide too early. Now, what happens at trial, and this is what happened at Sam Bankman-Fried just 2 weeks ago, the judge says, wait, you're taking the stand? This is Judge Kaplan. And the lawyer said, yeah, against our better judgment, our client wants to take the stand. He took the stand in front of the jury, and he wanted to kind of bring up like an informal, there were lawyers out there, and I relied on them in this crypto fraud that they've alleged, and he indicted him for. Judge says, no, you're not doing that. We're doing this methodically by the book and the 4 elements of your reasonable reliance. So he threw the jury out. He basically tells the jury, the lawyers and I have some work to do. So take an early lunch. We'll see you back, and we'll bring you back when we're ready. And they put Sam Bankman-Fried on the stand in front of the judge to be asked questions. We call that process a little bit confusingly often a voir dire. We voir dire the witness to hear what he has to say about the issues. And so the lawyers for him tried to establish the reasonable reliance, the full and complete provision of information, the advice back, the reasonable reliance, the good faith reliance, and all that. And of course, the prosecutors dove in cross-examination to establish that none of those elements were present. And by the time they were done with that hearing, the judge had made his ruling that you can take the stand, but you are not to raise the issue of that you relied on lawyers to suggest to the jury that you have a reasonable belief that what you were doing was lawful and legal because you relied on jurors to defeat mens rea or criminal intent. That's what's going to happen here. We're seeing Act 1 of a 2 or 3 act play. Act 1, Trump has to provide the lawyers and the documents and the attorney-client privilege information and waive his privilege and give it all over to the judge. And then Act 2 is if he decides to take the stand. He doesn't have to decide that now. Yes, now he's waived his attorney-client privilege by the 15th of January. If he decides to take the stand in the March trial, at any point before the case goes to the jury, and he decides he wants to assert that privilege, I think the judge is going to hold, this is Act 3, is going to hold a quick evidentiary hearing to have him sit in a box and have his lawyer and the prosecutors ask him questions and cross-examine him and examine him on these 4 fundamental items. And the judge then is going to make the ultimate decision, in this case, Judge Chutkan, as to whether this defense goes to the jury or does not go to the jury. But I love everything about how this is being played out. I think it didn't come up in the FTX trial because he never claimed so early on, to give the judge time that he was going to rely on advice of counsel. But since John Lauro, the lawyer for Donald Trump, Alina Habba, and all the rest, love to go on television to talk about the reliance on advice of counsel, that Donald Trump had exquisite and really well-known and exemplary constitutional scholars, I guess that's John Eastman, advising him, remember, all these lawyers I've mentioned, Eastman, Powell, Troupis, Ray Smith, Chesbro, Giuliani, Jenna Ellis, they have all either been disbarred or just barely missed being disbarred. And most of them are either indicted or already convicted criminals. Doesn't make for great good faith reliance on advice of counsel when your lawyers are all crackpots and now disbarred and criminals. But of course, the jury will know all about that, especially if he tries to invoke the attorney-client privilege. If he tries to, the reliance on advice of counsel. It's fair game then if that's going to go on the stand for the government to say, let's talk about all these lawyers. Jenna Ellis, convicted of a crime related to her work in your conspiracy? Yes. Rudy Giuliani, indicted and or convicted, lost his bar license? Yes. John Eastman, lost his bar license, indicted? Yes. And maybe convicted? Sidney Powell, lost her bar license? No. Convicted criminal? Yes. I mean, I'd love to do this part of the cross-examination. So that'll be in those three stages. And we'll watch as Judge Chutkan, as we're watching her do her gatekeeping function to protect the jury and make sure that only credible evidence and defenses end up in front of that jury. We'll continue to follow developments like the one with Judge Chutkan ordering Donald Trump to or get off the pot by January 15th on his reasonable reliance defense and waive his attorney-client privilege to boot. In that recent order. We'll do it in one place exclusively on the MeidasTouch Network on Legal AF, the leading podcast at the intersection of law, politics, and justice, and on hot takes just like this one. You like hot takes? I like them. You'll love what we do on Wednesdays and Saturday nights at 8 p.m. Eastern Time in a YouTube podcast recording on Legal AF and then on audio podcasts wherever you get them. So give me a thumbs up if you like this content. Helps keep the ratings up. This is my visual for helps keep the content rolling. And until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.